going back to the point of clause 12 versus 79. I mean, the argument whether respondent is exempt from liability works under both, but I would say it's a strategic decision whether you're claimant or respondent to argue one or the other or the two together. You can argue that there is no derogation from Article 79. You can argue that there is partial derogation from Article 79. You can argue that there is full derogation from 79. It depends on what serves your client. What are the relevant sub-paragraphs from Article 79 that you are relying on in the present case? 1 and 4, 79.1 and 79.4. 79.1 talks about the requirements to be exempt from liability. Okay, what does 79.4 talk about? Notice within a reasonable time, right? What does clause 12 say?
Like he said, the notice within 5 days, clause 12.2, and clause 12.1 concerns the force majeure events and gives a list of events.
Okay, you said it gives a list. Can someone read us clause 12 of the contract, 12.1 of the contract?
A party is not liable for failure or delay caused by events beyond its reasonable control, including but not limited to acts
beyond its reasonable control. Is that similar or identical to 79.1? Reasonable for you, reasonable control beyond its reasonable control is similar to what's the requirement under 79.1? Beyond its reasonable control will say something different. Each word matters. Beyond control. So there is is there a difference between beyond its control or beyond its reasonable control? Does the word reasonable change something? Okay, so he's saying that the threshold might be higher under clause 12. Who says it's lower under clause 12? You consider it?
I consider it lower because with reasonable control, you can kind of demonstrate what would be reasonable, but with beyond its control, it's a bit too general to demonstrate.
What are you relying on when you're mentioning the requirement under 79? How are you interpreting beyond its control under 79? Do scholarly opinions define beyond its control? Advisory council opinion?
According to Advisory Council Opinion number 20, beyond control, it's an event that is of external and objective nature. And also scholar opinions said about contractual allocation of risks, that beyond control, this event should not be allocated, should not be a risk of some of the parties, one of the parties. Easier to prove that it is lower, but as for me, they are identical standards because, yeah.
Both options are possible, depends on what serves your client better. But if we look at clause 12.2 of the contract and Article 79.4, is there a difference or a slight difference with regards to the notice?
In Article 79.4, they only require that the notice be given in a reasonable time. However, clause 12.2 is specific and requires a notice to be given within 5 days.
Within 5 days. So at the very least, you could argue there is a partial derogation from 79, in particular 79.4, to say that they specified what constitutes a reasonable time. Right? Whether you opt for a derogation or for them to apply in tandem, that's up to you and what serves your client. There is no better way. It depends on your line of argument and the impediment you're opting for. Now, going back to Article 79.1. What are the requirements?
There are three main requirements: being beyond control, impediment should be also unforeseeable, third unavoidable, and also that there should be a causal link between an impediment and a failure.
Some argue 5. So first you need to prove that it's actually an impediment. There is a causal link between the impediment and the failure to perform. It's unforeseeable and unavoidable. So you cannot avoid it, overcome it, or its consequences. So it's 4 or 5 requirements. As claimant, do you need to prove all of them?
No.
Okay, because the requirements are cumulative. As respondent, you would have to prove that all of these requirements are met. And this is where the strategic decision on who should start comes into play. Legally speaking, respondent has the burden of proof. It should prove that it's exempt, but it's much better to let claimant start because you will have an idea what they are considering as an impediment. And then strategically, you can say that's not the impediment. This is what we consider the impediment. Can you tell me what is the impediment you're opting for in your line of argument? What is your main impediment that caused respondent's failure to perform? And which obligation did respondent fail to perform under the contract?
The respondent failed to get the import permits. Yes. Clause 5, yeah. 5.2.
Something else.
Respondent's failure is to accept the delivery and to pay it for it.
Failure to accept delivery. Which one is more strategic for respondent? Failure to obtain the permit or failure to accept delivery?
Obtain the permit.
To obtain the permit. So what is the impediment that made it impossible for a respondent to obtain the permit?
Import restrictions by the government.
The import restriction by the government. You're all using the import restrictions? I'm gonna hear you plead in a couple of hours. I would know. And I will hear you tomorrow. You're using the obligation to accept delivery. And the impediment for that? Respondent refused delivery thrice. Based on what? You're using different impediments. What are the impediments?
First, that the respondent did not accept delivery. Second, failed to get the import permit. Third, couldn't cooperate in performance. As a claimant, I'm stating that 3 points in my issue C argument. First, that the respondent did not accept the delivery. Second, that he failed to take the import permit. Third, that there was a non-performance from his side.
If we consider that the failure to take delivery is the failure to perform, that not taking delivery, that's what respondent failure was. Okay? What's the impediment that caused this failure?
when the whole thing, when the vanilla import, the trade of vanilla orchids shifted to Appendix Sites 1? Yes.
That's for the causal link. How are you going to prove that it was foreseeable, unforeseeable? No one is arguing that there is no impediment. You all believe that there is an impediment that caused respondents' failure to perform. As claimed, no one is arguing that there is no impediment to begin with. No? Is it possible to argue that there is no impediment to begin with?
It is possible to argue since the place of delivery is in Mediterranean, and for the delivery, the import permit to Equatoriana is not necessary. According to the Incoterms 2020.
So the Incoterms that the parties are using are not publicity to the ICC Incoterms. There is a reason why it was shifted, and the FCA means something. Did any one of you check what under FCA, capital city immediate, what does it mean?
The FCA means that the respondent will be responsible for the transportation. It means that claimant will transfer the vanilla orchids to a middleman who will then transfer the vanilla orchids to respondent who is responsible.
Could you clarify? Where is claimant supposed to deliver the orchids? The place of delivery. And where is the respondent is supposed to take delivery?
When claimant made goods available for the delivery in capital city in Mediterranean, and the respondent should take them in Mediterranean also.
So actually the place of delivery is Mediterranean, in particular the airport. Does Mediterranean have any sort of restriction as to vanilla orchids? They're very flexible, right? There is no permits required at that point in time for respondent to take delivery. Does the risk shift from claimant to respondent at that point in time? Yes, it does. So the ones who are arguing import permit, you need to find a way to circumvent this issue because there is no need for an import permit to actually take delivery according to the contractual terms.
Yeah, but when we had the contract, we amended, we made 3 amendments. And one of them is we have the exclusive right to choose between a time frame because we had a greenhouse to be constructed for those orchards. So
that's a different kind of impediment, that your greenhouses were not ready and you couldn't accept delivery because you need to put the orchids in these greenhouses, otherwise they will perish. That's a different kind of impediment. Would you argue this under 79.1 or under a different provision? If you're going to argue the greenhouses, does it fall under 79.1 or a different provision of Article 79? In the chat, someone said 79.2, a third party that caused respondents' failure to perform. That's why it's very important to identify the impediment that you're using to exclude or not exclude liability and the causal link to a particular obligation for respondent. If you're using greenhouses, it's a different legal basis. If you're using the import permit, you need to find a way to circumvent the Incoterms used and the shifting of the burden in terms of risk, allocation of risk under the contract. That's why I'm pretty sure you heard the word respondents bear the risk. He took responsibility over this particular matter, contractually speaking. causal link, unforeseeable and avoidable. How are you going to prove that it was really unforeseeable or foreseeable?
Our main impediment is the shift in equatorial policy, and we would prove that it was unforeseeable since Equatoriana historically complied leniently with ICI's obligations, that its approach was historically, and the change of this approach was not foreseeable.
So the shift in granting import permits, also the trade, the restrictions, were unforeseeable because that wasn't Ecuadoriana's long-lasting position with regards to the trade of orchids. Yes? Now, if someone were to argue that it was indeed foreseeable for respondent, how are you going to circumvent that? Let's say you will have him as your opposing counsel, and he argued that it was unforeseeable. How are you going to prove the contrary?
First, the vanilla orchids were included in Appendix 2, which means that they were already an endangered species. So respondent could have foreseen that there would be possible restrictions in order to reinforce their protection. Second, state interventions always change, so respondent should be aware of such a possibility.
Is there any reference in the record that could solidify what you're saying?
For the inclusion of the vanilla orchids into Appendix 1 and the fact that they're endangered, it's in the Notice of Arbitration, page 4.
Your claimant, right?
Yes,
You cannot use the notice of arbitration.
even if it's an undisputed fact.
Even if it's an undisputed fact, it's somewhere else in the record. There are the first exhibits, claimant's first exhibit. There is claimant's first exhibit, the witness statement.
In Claimant Exhibit C4, it states that the vanilla orchid was moved from Appendix 2 to Appendix 1 with immediate effect.
So you're using the immediate effect. No, we're asking about the fact that it was foreseeable. How are you going to prove that it was foreseeable, that this could happen at any point in time, that this is not a shock?
In September 2023, the site standing committee did recommend the Appendix 1 listing. It is mentioned in the record and Peer 2. Also, and from that moment, the respondent was aware that something good like this happened. And yeah, he could have applied for the permit way earlier than this.
There's page 7, Claimant Exhibit C1, paragraph 2. The vanilla orchid is extremely rare and its natural habitat is limited to Mediterraneo and 4 other countries.
Okay. Before I go back to you, that's yes. See, use that instead of notice of arbitration. Going back to you. When we're assessing that it was unforeseeable and unforeseeable, what is the point in time where we should assess? At which point? What is the relevant point in time where we should do all of these assessments? Contract? At the contract, taken into account circumstances that happened before the contract conclusion. What you're referring to happened before or after the contract was concluded? After. So you cannot say that it was foreseeable because of something that happened after we concluded the contract. The fact that species moved from Appendix 2 to Appendix 1 has never happened before? Or it did happen before? vanilla orchids are the one of a kind. It's the first time ever that a particular species changed from Appendix 2 to Appendix 1? Or did this happen before?
This happened on every size conference before. Every size conference, there is discussion of transfer from some species from Appendix 2 to Appendix 1 sites.
Not only this is practical knowledge outside of the moot problem that you could use, but also we have a similar case, something in the case file that says that in a lumine case, there was a species that shifted from Appendix 2 to Appendix 1. So the fact that a species could change from Appendix 2 to Appendix 1 could happen. Is there any other relevant fact that proves that this was actually foreseeable? And if I'm asking, it means there is. Okay, someone is asking that the lumen inclusion was mentioned in the notice of arbitration. That is correct. But someone, Amuti, asked about it and it was answered in procedural order number 2. So you can rely on the question itself in reference to the notice of arbitration to give it some weight. Any other fact that says it was foreseeable? It's after the conclusion of the contract. Something at or before the conclusion of the contract. Did you all read the contract very carefully? I'm asking about whether or not the inclusion or the shift from Appendix 2 to Appendix 1 is foreseeable. Is it foreseeable or unforeseeable? I saw you that you laughed, so you know what I'm talking about. No? No? Did you find it? Share with the class.
In definitions, it says CITES means the conventional international trades in endangered species of wild fauna and flora, and then as amended from time to time.
The key term being as amended from time to time. Did they foresee that this particular convention would be amended? Is it something that they foresaw in their contract? Makes it foreseeable. Now, what could respondent use as a counter argument? Your favorite idea.
That it had immediate effect.
Immediate effect.
On page 3 of the record, it says that, yeah, page, yeah.
You're using page 3 of your notice of arbitration, your lawyer's words. But what does it say? We will try to find something similar outside of the note.
Yes, so when the plants, when the whole vanilla orchard thing was first discussed, when it was not in action, but when it was discussed, the claimant did approach the respondent about the same. And to which the respondent's party replied with that they would apply for an import permit earlier so that they can do a successful delivery.
That doesn't counter unforeseeable, in my opinion, but it counters it was avoidable because these discussions happened again after the conclusion of the contract. You can use everything to say it was foreseeable, unforeseeable if it happened at the time of the conclusion or before. Anything that happened after, you could use it to say it was actually at least avoidable. Okay, so the issue of immediate effect that's the unforeseeable aspect of the inclusion. Before, how did things work before? How much time did the parties have?
90 days.
90 days, 3 months. Okay? How can respondent counter argue this? The 90 days thing. The claimant could argue to counter argue this. It doesn't matter that it was with immediate effect. Or you would give up at this point and move on to the fact that it was unavoidable. It was avoidable. Sometimes you need to choose your battles.
It doesn't matter that it happened with immediate effect because respondent was aware that conference XX8 could take place, could be enforced at any time, even if it hadn't been enacted before.
So it's a part of the convention. Just because they haven't used it before doesn't make it unforeseeable. Okay? Now what about unavoidable? Can you please once again deal with unforeseeability from respondent's side? Can you please elaborate why we deal with unavoidable in the meantime? Was it avoidable, unavoidable? And what was avoidable, unavoidable? The impediment or its consequence? Depends on which impediment you're using. You were a bit late. We discussed which impediment everyone is using. Is it the import restriction? Is it the inclusion of the vanilla orchids? Is it the inclusion of the vanilla orchids with immediate effect?
I would say the consequences are unavoidable because on page 57 of the record, C5, it says that any early delivery would put at least 2/3 of the vanilla orchid to be delivered at risk at commercially unreasonable costs, putting an excessive burden on respondent.
Why is that claimant's problem? Because it became excessively more onerous? Does excessively more onerous constitute an impediment, or is it a different thing? It's a hardship or a force majeure? It's a hardship, so it's a different thing.
However, according to scholars, the obligation to avoid the impediment or overcome its consequences is limited to reasonable efforts, and that should be it should not cause too much harm, especially if we have the situations and in the contract, this time of delivery was to avoid this harm, to this time period for delivery was for respondents' interests, and it acted in accordance with contract to avoid its harm.
Let me ask you a question. Claimant that the respondent, at least in its second submission, is insisting that it had the right to determine the number of orchids to be delivered. They had 3 greenhouses, one of them was ready. Why didn't they accept 1,000 out of the 3,000 or the 3,300? They had one greenhouse already. Why not accept a partial delivery? Partial deliveries are a thing under the CIG. They're accepted. Why?
First, under the contract, partial delivery is not possible, only at least 2,700 orchids. Second, it would not reflect the respondent's interests because it's not interested in 1,000 orchids. It's interested in 3,000 as they agreed and plus or minus 10%, but 1,000 orchids could not be used. It's not part of the contract.
So it's more about your client's convenience. Rather, because accepting 1,000 in one greenhouse, it's like meeting claimant halfway, mitigating the loss, because respondent should also act in a reasonable manner, right?
Right, but duty to avoid also implies that a substitute performance should reflect the original interest of the contract. And if we supply only 1,000 of orchids, it would not reflect the original interests. We should not rewrite the contract for the parties to mitigate losses of claimants. It's a common risk. It's problem not only for respondents, and all risk should not be shifted on its side.
Does anyone else have any different opinion? Who would like to counter argue? It's a very nice opportunity to work on your rebuttals.
Even if respondent wasn't able to accept earlier delivery, it could have applied for an anticipatory permit to avoid the alleged impediment from happening in the first place.
Time for some hypothetical questions. Let's say respondent did apply for this anticipatory permit. Okay, they have the anticipatory permit. What guarantees that due to the shift in the Equatorian government that they won't halt them at the in Equatoriana? It won't the goods won't pass because the government changed its mind with regards to the vanilla orchids.
Because the government of Equatoriana started the practice of granting anticipatory permit because it was against the listing and it wanted to allow vendors the opportunity to trade in it before it came to pass.
You answered my question, but now they're not against the listing, they are with the listing. So the comparable case is not really comparable. The Lumen case is not really comparable to our case because then at that particular case, Equatoriana was against the listing. That's why they granted these anticipatory permits. Now they are with the listing. They changed their mind. So to which extent would that have worked? Even if they got the permit, let's say they have it, would they have been able to actually take delivery?
Yet claim a force majeure. Only at that point would it be considered a force majeure event. And since that had not happened yet, it cannot yet be considered a force majeure.
That's why it's very important to identify what is the impediment and what was the obligation that was breached. That would be valid if my argument would be the impediment is getting it wasn't possible for our client to get the import permit. But if I say it wasn't possible for our client to take delivery, then we would still not be able to take delivery anyways. Even if we had the import permit, there is no guarantee. It's not in the case file though, but there is no guarantee. Someone in the chat said they should have taken anticipatory permit in November 2023. when they did not take a restrictive approach. That's what we're discussing, right? Even if, let's assume they have the permit, is it guaranteed that with the permit they can take delivery? These orchids could enter Equatoriana with a permit? That's the question. Because according to the record, Equatoriana has intentions to abolish the trade of orchids. What's the value of a permit if that particular species cannot enter anyways? That was my hypothetical question. You have something to share?
It can be used for kids. That the Equatorian, no, that the respondent was trying to use 300 of the vanilla orchids for research. Anything related to that?
I think, my opinion, it's not. My personal opinion is that you could use that to say that they could still have mitigated the losses by accepting partial delivery of 300 vanilla orchids. That would justify the research purposes because they could still get a permit for research purposes in line with the CITES convention. So they could have accepted at least the 300 orchids out of the 3,300 or 2,700 to do research. How can respondents say that it was unforeseeable at the time of contracted when it is explicitly mentioned in the contract? We stopped there. We said, should respondents still insist that it's not respondent, that it was unforeseeable? Here it's about the permit, right? With regards to the CITES, I say you need to do more research to see what the usual amendments include. And then you could compare. Does it amount to the present case or not? Let's say you're taking a different route. You're using clause 12. What do you need to prove under clause 12 to be exempt?
The respondent would say that the event was beyond its control regarding the government measures. I don't have the full clause, but I have it paraphrased. 12.1 excuses liability where failure
Okay, so under clause 12.1, events, a party is not liable for failure or delay caused by events beyond its reasonable control, including but not limited to acts of God, extreme weather, epidemics, quarantine, embargoes, and government measures, and natural disasters and weather interruptions.
How many requirements are there under clause 12.1 for respondent to be exempt from liability? More than one. No. 11 requirements? To be exempted from liability, what are they?
Beyond control, foreseeability, and avoid or overcome. Oh, from the clause, they're around like beyond control. Yeah, one only. An event beyond its control.
So an impediment beyond reasonable control and the causal link. How many requirements do we have under 79? 4 to 5. We went through them. They are 4 to 5. What's easier then to prove? What's much easier to prove? For respondent, it's clause 12. You have less requirements to prove. You don't need to say that it was unforeseeable or unavoidable. You only need to prove that it was beyond its reasonable control and that it caused its failure to perform. An event that is causal to the failure that was beyond the party's reasonable control. You got rid of the most difficult 2 requirements to prove.
But what about clause 12.2, in which we can find maybe criteria of avoidance? I would quote, the affected party shall, and further it reads, use reasonable endeavors to mitigate the effects. This is kind of requirement of avoidance.
So mitigate the effect, which brings us back to the idea, should a respondent have accepted partial delivery, at least the 300 orchids? And the notice. Do we have an issue with the notice that respondent didn't notify claimant? Do you repeat the question? Do we have an issue with regards to the notice that respondent did not notify claimant? That they need to notify claimant? Whether under clause 12 or under the article 79 for it.
It seems that there is no issue regarding notice because about all the events claimant already knew. Claimant knew about the change of sites convention of sites. Claimant knew about immediate application. As regarding governmental the change of issuance practice, the discussion between claimant and respondent was held in 2 days after the announcement, so 5-day period is also complied with.
Basically, you're saying that claimant was up to date. There is no need to tell them what they already know. Do scholars' cases align with this idea? Yes, they do. Okay. Assuming that you could prove that the notice, the requirement for the notice is not met, what would claimant get out of that?
It could claim only damages for non-notification.
Other damages. The same damages or other damages?
Other damages.
Other damages. But not the 3.3 million. It's a set of other damages that you could claim. Not what claimant is seeking. The 3.3. The issue for respondent is that in reply to the notice of arbitration, it sought relief under 79 and under PO2. that they will seek exemption from 79, and if it falls, they would go to clause 12. What is more difficult to prove, 79 or 12? 79. So if you can prove exemption from 79, it's much easier. It's basically you have 4 out of the 5 requirements replicated in 12. So if you could prove under 79, the same requirements or slightly different requirements are under 12, which are easier to prove. Now, what are the things that you're struggling with regards to your first submission that you really want us to discuss?
For respondent, it's hard to find a rebuttal for the fact that state interventions are foreseeable. So it's hard to prove that it was truly unforeseeable.
I could tell you that most commentators on the CISG state that practically all the events that lead to an exemption are foreseeable in one way or another. What matters is, were they foreseeable in the present circumstances?
I would say that yes, because the vanilla orchid's already an endangered species.
But both the countries involved are very lenient with regards to this.
But that could easily change since they are governments and government measures can always change.
You're talking in an abstract format. We're talking about our case. Any assessment under 79 should be done on a case-by-case basis. Were there any signs in the record that Equatoriana would be willing to shift?
At the time of conclusion of the contract, no.
That's what matters. You're looking at what happened after the contract to justify that it was foreseeable at the time of conclusion. That's the facts that you're relying on, that they shifted their their policy with regards to grant and import permits. But all of that happened after the conclusion of the contract. You have to make it very clear that what is relevant is what happened before or at the time of the conclusion of the contract. There were no signs. And that's what matters for the parties. That's what matters for respondent. For claimant, it could use everything that happened after the conclusion to say it was avoidable. One way or another, it was avoidable. We told the respondent multiple times that there is an issue. Did claimant reach out to respondent very early on and say, are you still on for this contract? Or should I find another buyer? They did.
I was just going to say that also claimant suggested to deliver later on for respondent at the end of the year of 2024. Sorry. A new batch.
That's a fact that you need to use for your second submission. Yeah, so be wary of what you say, that because it could be used against you in your second submission. Claimant was very willing to find ways to make sure that this contract is executed in one way or another. They said, okay, if you cannot accept delivery now, it's fine. We can deliver at a later date that is convenient for you, but we will shift this batch to another buyer, and we will sell you the orchids you want from a new batch that we're growing at the moment. But be wary of these statements because they will affect your arguments with regards to the cover sale under 75. Because you need to sell the same goods, right? Any other issue? You're confident in your arguments? Not anymore? That's a good start. You're sure you don't have questions? Any questions? Ready to hear you. First submission, I won't answer about the second.
For the fact that was clarified in procedure order number 2, that the vanilla orchids grown by claimants are artificially propagated.
I'm pretty sure you read the arbitrator's analysis. It's available on the Vismut website. It says that for a species to be protected under Appendix 1 or Appendix 2, whatever, it needs to be naturally propagated. In the case at hand, at some point, the orchids that claimant grows are artificially propagated. Or at least you cannot discern what was artificially propagated and what was naturally propagated. So there is an argument to be made that they don't fall under the CITES to begin with because they are artificial. So there was no need for a permit. It could be an argument. It's there in the arbitrator's analysis. You could be asked about this. So be ready to answer this kind of question. It's an argument to be made, but it's a difficult one because you could counter argue that we don't know the percentages of what was artificially propagated and what was naturally propagated.
I have the question, which is quite opposite to the ones that was previously asked. What are indications in the record in the problem that the shift of issuance policy could be foreseeable? For respondents, it is convenient to argue that historically there was linear compliance, but what about claimant in this situation?
You mean, was it foreseeable for claimant? The impediment was foreseeable for claimant too. Well, the rule is clear. It's not about the party in breach, it's the parties. So you need to prove that it was unforeseeable or foreseeable for both parties. But claimant is quite versed as well in the sale of orchids, and they have clients. So they know how Equatoriana operates. And they were relying on that. They reasonably relied on Equatoriana's trend in granting permits. But again, it was foreseeable to claimant as well, in which sense that they don't just sell to Equatoriana. And it was mentioned in the record that only Mediterranean and Equatoriana are very flexible with the permits, right? What about the other countries involved? They're not flexible. So they know about the shift and how import permit could come into play. So it was also foreseeable for claimant. You have a question?
No, we're still in French.
You're still there? You didn't read the arbitrator's analysis?
There's the third paragraph of the PO2 that is an easy answer to such argument.
Read it.
So up to 10% of parental stock per year is sourced from wild plant to maintain genetic diversity. Secondly, in May 2021, a disease outbreak destroyed approximately 30% of the claimant propagation stock. So actually, we can't know if the vanilla orchids that will be delivered are part of this 30% or not. Plus that the 10% parental stock is actually naturally propagated. So the stock of vanilla orchids that is sold is affecting wildlife. So
That's particularly the counter argument that we cannot really tell, but it's 50%, 10%, 20%. We cannot tell what was naturally propagated and what was artificially propagated. But there's an argument to be made that the majority is artificially propagated. Just be ready to
but size doesn't talk about majority. It is a yes or no question, at least for respondent.
What's 10%? What's 15% out of 3,300? Isn't respondent insistent that they only need to get 2,700?
Can be.
So basically, potentially the 2,700 could be artificially propagated.
No, they're actually all naturally propagated because there's parental stock.
10%. It says 10%. The parental stock constitutes 10%. Read us the last line.
Due to the emergency, all material will propagated together and the wild sorts cuttings were not spread or labeled.
So
Separated or labeled.
So we don't know. The answer is we don't know.
Then we need a permit for everything.
That's
the
argument.
argument.
But the experts could tell. They should hire an expert to tell them what was naturally propagated or not. I mean, they can hire an expert for this case.
Why not?
Just go with the flow if you get asked about the question. Give solutions, like practical solutions, because these are hypothetical. We really cannot know. There's nothing in the record that would indicate this or the other. But you cannot stay silent and say we don't know. You have to come up with some sort of answer. Any? Because we're done. But any pressing question? Any other question?
Just one thing, because you said if the claimant says that you could have at least taken the 300 orchids, shouldn't the respondent just agree with this and close it there? Isn't it good for the respondent to accept this?
What would respondent do if he takes now the 300 orchids? What would it do with them? Research? They can't do anything. Why can't they do anything? No, they have no. The abolishment of trade is something that they are foreseen for the future. But that's not the point. They're gonna decorate their company with them because they sold their spice business. Respondent sold its spice business. So what are they gonna do with the 300 orchids? What would you respond?
I would respond that even that's all we should reflect the interest of the party, and of course there was interest in research, but only combined with subsequent commercial use. That's why the number of orchids under the contract is not 300 as what is original with Botanical Garden. This is why the parties amended the contract and change it.
He's insisting on the 2,700. It's 2,700 or nothing. That's his position. Any other questions? No? Then with that, I rest on my submission. See you after the break. You're welcome.